Good morning. Are you Charles Darling? And Mr. Darling, in cause number 24, DCCR 1384, you're charged with the third-degree felony offense of stalking from April 11th of 2024. And what that means is that if you go to trial and you're found guilty, the range of punishment is between 2 years and up to 10 years in prison. Do you understand? And I have here on the tablet a plea bargain rejection that has your signature on it with that of Mr. Lewis's that shows that the district attorney's office has made an offer, if you wanted to enter a plea of guilty, to plead to a reduced charge of a Class A misdemeanor of harassment for a 1-year deferred adjudicated probation. You have every right to reject that and have your case set for trial. I want to make sure you understand what the possible consequences are and what your options are, and do you understand all of that? And do you want to reject that offer and have your case set for trial? I'll do that. I do want to make sure you understand, Mr. Darling, that after today, I will not accept this plea agreement. Obviously, if you didn't do it, you didn't do it, but this is quite a reduction and a good deal if you did. But I'm not going to accept a misdemeanor reduction after today. Once your case is set on the trial docket, it is going to go to trial, or it would be a plea to something different. Do you understand? All right, so we'll get it set on the trial docket, and you're appointed. Mr. Darling, Mr. Lewis has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him, and I can appoint another attorney today who could begin preparation for trial a little quicker. Is that okay with you? All right, so Mr. Lewis, you'll remain on. He will begin preparation for trial. Make sure you stay in touch with him. He'll let you know when you need to be back. Right?
Man, just so the record is clear, I don't have any indication that there's been any issues between the complainant and the defendant. We just admonish him again as to the no contact. I will also reach out to her again. We've had several conversations. Let her know kind of what juncture we are, what she wants to do, and I'll let the court know something well in advance of the trial.
Okay, thanks. So I want to make sure you understand, Mr. Darling, it's a condition of your bond that you have no contact or communication with Quandisha Celestine. You understand? Okay, so that means you're not to be in contact with her personally, but also you're not supposed to send messages. Don't send anything on social media, text messages, anything like that. Do you understand? If I find out, she can't give you permission to do that. So she can't say, no, it's okay, it's fine with me, come on over, or let's do whatever. She can't give you permission to violate my court order. If you violate that court order, then your bond will be raised, and then you'll be back in jail waiting on trial. Do you understand? Okay.
And I will let her know this may be what he wants to address, that goes for her as well, Judge. I think there has been some communication directed at him, and I don't want him to accidentally violate because she's doing that. I can't tell her what to do because she doesn't have a case pending in front of me. I can only tell you what to do. So Ms. Malfino is going to talk to her, but if she contacts you, your response is, I can't talk to you. Don't respond. Let her know that up front. She's going to let her know that. No more communication, no contact until this case is over. Understand? Okay. All right, you're free to go.
All right, thank you, Judge.
Are you Anthony Vidal?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
Judge, you may recall on this case, we discussed maybe a restitution deal. He's in a group home, and after meeting with his team, we ended up agreeing to do a 1-year deferred to a Class A misdemeanor. If we didn't write it up right, that's on. I didn't catch it. And pay that full restitution over time.
Okay. So it's a...
Class A criminal mischief.
All right, and will he waive the formal reading of the indictment?
He does, Judge.
Mr. Vidal, in cause number 24, DCCR 2062, the state is elected to proceed on the lesser included offense of a Class A misdemeanor criminal mischief from July 26th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily, and because you did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state's marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for 1 year deferred adjudicated probation. There would not be a fine, but there would be restitution in the amount of $3,025. Is that your understanding? And are you a U.S. citizen?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Bless you. Is there any evidence that Mr. Vidal is not competent?
No, Judge.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 1 year.
Yes, ma'am.
You're ordered to pay restitution in the amount of $3,025 and to follow all of the other rules and conditions of probation. If you do all of that, this is a great opportunity because you don't have a conviction on your record. And at the end of the probation period, if you're successful, the case is dismissed. The other side of that, though, is if you violate any condition of probation, you can be brought back into court and you could be found guilty and sent to the Jefferson County Jail for up to 1 year. Do you understand? I'm handing you the trial court certification that shows this was an agreement that I followed, and so you have waived your right to appeal. You just need to have a seat here in the courtroom. Probation's going to call you up to her desk when she's ready to go over all of your paperwork, and she's at that desk right there, so just watch for her to call for you, okay? All right, good luck to you, sir.
right,
Thank you.
Thank you, Your Honor.